Good afternoon, everyone. Carly Hanson at Community Legal Centres Queensland, presenting today our webinar on Runaway Robodebt Train Derailed with Professor Terry Carney as our presenter. So thank you for joining us. Before we do get started, I'd like to acknowledge the traditional owners of the land on which we're meeting today. In Brisbane, where we're located at Community Legal Centres Queensland's office, they are the Turrbal and the Yagara people. I wish to pay respect to their elders, past, present and emerging, and acknowledge the very important role that Aboriginal and Torres Strait Islanders continue to play in our society. As today's webinar is being viewed by people throughout Queensland and Australia, and Terry's presenting from New South Wales today, I'd also like to extend my respects to the traditional owners of the land throughout the country and extend a very warm welcome to any First Australians joining us today. So as I mentioned previously, we're very fortunate to have Terry Carney from the University of Sydney joining us to present on the runaway train that is Robodebt. So just for a little bit of background, many of you may know that in November 2019, the federal court ruling invalidating the Department of Human Services, which has now changed its name to Services Australia, I believe. So Centrelink, we're talking about, around their data matching scheme. So the scheme, as you know, is commonly known as Robodebt, and it used data matching to raise social security debt solely on the artificial and arbitrary basis of the ATO's averages of fortnightly incomes. So today, Terry will discuss some of the legal and practical implications of the Robodebt scheme, why those debts lacked any foundation in law, and the position of the about 500,000 people who've been affected by the scheme to date. Terry will also look at the situation of people who've had a debt paid already, or had it garnished from tax refunds, or have an outstanding debt, or are currently dealing with Centrelink's current review of all of those matters. So some information about Terry's up on the page that we've advertised this session, so I won't cover all of that, and I'll let Terry introduce himself a little more in a moment. But just to get some housekeeping out of the way, today's webinar is being recorded, and we'll have that recording available for you to download hopefully tomorrow from our website. So if you've registered, you'll receive an email from me tomorrow with that link. The PowerPoints have also been uploaded to our webpage, and I've uploaded them to the GoToWebinar control panel for you to download if you didn't catch those already. We'll hold questions to the end as we usually do, but feel free to type your questions into the question box as we go through as you think of them, so that we can deal with those at the end. So I'll read those ones out for Terry to address. If you haven't asked a question on this session, this kind of session before, there are two ways you can do it. You can press the button that looks like a hand on the GoToWebinar control panel as you did earlier. We'll see that hand come up and we can unmute you. So do that if you've got a microphone that is working. Otherwise, the easier method is just to type your question into the chat box or the question box, and we'll read those ones out. So I might now hand over to Terry to get us started on today's presentation. Thanks, Terry.
Thank you very much, and welcome everyone. And I too would like to pay my respects to the Aboriginal land on which, from which this is being broadcast down here at the wonderful Shoalhaven. Thank you for the introduction. As was mentioned, I think on the screen, which I can't see, but I am an emeritus professor of law, and social security has been my principal area of research. It's not hard to become Australia's leading expert, because there's virtually nobody else in academia these days who looks at social security at all. And as I think many of you would probably know, for just on 40 years, I was a member of the what became the Administrative Appeals Tribunal. Prior to that, the Social Security Appeals Tribunal. And if you've been watching the press, or at least reading The Guardian in the last 5 days, you would have seen that very early in 2017, I decided and invalidated Robodebt at first level AAT, and that decision, at the request of the Senate, was published just a few days ago. As I'm sure you all know, at first level administrative appeals tribunal in the Social Security division, so to speak, the decisions are not made public. I'll touch on this in a short while anyway, but while I'm on a run, there were some, we don't know the precise number. I decided 5 before the government decided it didn't need me around anymore, invalidating Robodebts, but a lot of my colleagues were doing the same. And so there were about, somewhere in my estimation, between 400 and 500 first tier AAT striking down of Robodebts and sending them back, usually with a direction that if Centrelink wanted to pursue the debt, it had to pursue it in the lawful way, which, as we'll see in a short while, meant by obtaining, using its own powers to do so, the fortnight by fortnight information, and asserting, as was confirmed in the federal court settlement, that relying on an average was no basis at all for raising a debt, none at all. And those of you who've read anything of mine in the sort of detail that will send you to sleep would have noted to that question, well, how many of those 400 or 500 cases did Centrelink choose to contest as being wrong and get that reversed by going to the second tier, the general division of the AAT? And the answer to that is absolutely 0. And that tells you something about how insecure poor Centrelink felt about the quality of whatever legal advice or reasoning they were relying on for 3.5 odd years to continue to raise debts on the averaging basis. All right, so that's all the introduction stuff. What you'd like to know now, because you probably already have started to fall asleep, and you're missing out, unfortunately, because you can't see me. That may be a great asset, but anybody who's seen me in person knows that I walk around a lot, jig about, and you know, that tends to keep people awake. I'm afraid listening to my voice will be no substitute for the likelihood that, you know, my boring presentation is going to get to you sooner or later. So for that reason, I, you know, tell you what I'm setting out to do. So very radical. I'm starting with an introduction. That I'm going to talk about why Robodebt was illegal. The reason that I'm going to be doing that is that it's fundamental to understand what the illegality is in order to be able to answer what the position is and what, as welfare rights advocates or other people interested, what advice should be given to people who already have a debt or are still having some contact with Centrelink. So we're going to talk about that. Then we're going to talk about the November 2019 capitulation. It's interesting because the capitulation occurred a week before it became public. Indeed, it occurred, as we'll discover, the night before. The government the next morning asked that it was tweaking, you know, making minor changes, as Mr. keeps wanting to say, to the way Robodebt operates. As we'll discover, that capitulation was total, and there's for the government and Minister Roberts' assertion that anything short of obtaining precise fortnightly earnings information for each and every fortnight of any debt period, there's no basis for saying that a debt can be raised or a portion of a debt raised on any other basis than that. I mention that because those of you who are familiar with the Minister's statement on the day and in Parliament and press releases and so on, talk about the government saying, oh, well, yes, we're not going to rely on an average alone. We're going to look for additional proofs. And that sort of weasel word language is illegal. One must obtain all the proofs. So that's what we're going to talk about, the capitulation. We're also going, perhaps in passing, and I might forget if I don't mention it now, this might also, that the fact that the settlement occurred by the government folding up its tent and then negotiating the terms of its capitulation that were made public a week later, that possibly accounts for, if you've seen the Attorney General's statement about a week later about what advice Centrelink had as the basis for raising these debts. And the attorney said, we didn't get external legal advice until, I think his words are to the effect, very late in the piece. It may well be that very late in the piece was the night before the 19th of November, if I remember the date correctly, change to the program. So we're going to talk about that. We're also then going to talk about whether you need more or complete proof of debts, and of course you know the answer to that by now. We're then going to look at the terms of the statement, the press release, and then the Senate hearings just before Christmas that elaborated what Centrelink is now doing to conduct methodical reviews of debts. And we're going to discover that although the original statements did not make that clear, in fact, what Centrelink is doing arose, whether it's been repaid in full, whether it was garnished, or whether it's still outstanding and so forth. We know that from the head of the section that is responsible for compliance in Centrelink, and those of you with eagle eyes, or perhaps those of you who actually listened in to the Senate evidence, will know that there are about 350, about half of the available staff, many of whom are casual actually, you know, they're not necessarily full-time Centrelink officers, are working on that, and Dr. Ros Baxter, who's the whatever she is, the first assistant secretary, or very senior, in charge of it all, indicated to the Senate that it was anticipated that those reviews to identify all the cases where averaging is the sole basis for the raising of the debt should be completed by towards the end of this month. That was being said before, you know, before Christmas. Who knows how it's going? I certainly don't. I'm then going to talk about the one-touch future, and one-touch may be totally unknown to most of you. It's a tax initiative designed by the tax office to try to address the underreporting of taxable payments and so on, but particularly employers who were, so it's an employer system, I should make that clear, and it enables them to fortnight by fortnight tell the tax office you know, what monies have gone where, so that those people who are entitled to a superannuation contribution get to be paid their superannuation contribution. And what in the last week, or was it a week and a half, the legislation to enable one-touch fortnightly employer reports to be matched with a new definition of what is a person's income if you're on a working age payment like New Start or the youth allowance, or etc. That legislation, well, talk about, is now in the Parliament, and it makes some quite interesting changes, which on the one hand will probably make the catastrophe of robo-debt something that's consigned to history, but perhaps paradoxically, it's going to cause a few conniptions in the future, particularly for pensioners with fluctuating earnings. There aren't a lot of pensioners who do have earnings, but and those that do, there's a reasonable proportion who will have fluctuating incomes, and it's not going to cope terribly well with that, as I'll explain in a short while. And then we're going to talk about the lessons for welfare rights and public law, and the, you know, so you're not hanging in anticipation. Public law and welfare rights and every other accountability institution was a complete and total failure for 3 years, and that makes you wonder, or certainly made Peter Hanks QC wonder 3.5 years ago in a paper, saying, well, way back in the time when he and I were young, Green and Daniels, you know, fixed up an equivalent abuse to Robodebt within a couple of months. That was before we had any of this. We didn't have an AAT, we didn't have judicial review, we didn't have an ombudsman, we didn't have any of these things, and it got fixed quickly. We now do have all these things. How come it took 3.5 years, essentially, for things to be sorted out? So then there'll be a conclusion, and then eventually you'll be able to read this boring stuff in the Social Security Rights Review piece, which, in case you're looking for it, won't include the one-touch future because it's still a bit too uncertain to know quite how that's going to pan out. So, you know this already in the introduction, that on the 19th of November, the government folded its tent in the second of the two challenges that had been brought against it. So it folded its tent and conceded it didn't have a legal leg to stand on in the Amato case, and then it took a week for the orders to be agreed. Peter Hanks was the QC senior counsel there, and as those of you who want to go and read the terms of settlement will know, he got everything he wanted. A total blanket legal invalidation of raising debts on the basis of averaging of ATO information, which usually was taken from 26 weeks. Sometimes it was a whole year's worth of earnings that were just divided to produce a fortnightly average. But in addition to that, of course, and the only reason that Centrelink didn't do to this case what it did to the other, namely exercise its power to waive the debt in its entirety, that's what it did in the previous case to Amato, and then say to the court, oh, look, there's no legal issue now, there's no substantive issue that requires to be decided. The only reason that Amato didn't go that way is that the claim here was because her debt had been repaid in part by Garnashi, she requested, and the orders provided, interest on the money that the Commonwealth unlawfully held for the period of time before the debt was invalidated and the money repaid. Where did Robodebt come from? Well, it was a a revenue-raising measure. It was originally, estimates varied over the 4-year period of the budget estimates. It was estimated to raise up to 4 or more billion, that's billion with a B, dollars, and it got ramped up just before an election, although a smaller version of this scheme came out in the mid-year budget statement before the election before last. In a couple of weeks prior to that election, there was a bit of a budget black hole, and the way of filling the budget black hole and not being embarrassed on the hustings was to quadruple or more the scale of the program. The government, of course, only just scraped back in. It didn't know it was going to be the government for sure, with its 1-seat ultimate majority for quite a long time. And to compound the fact that it was an ill thought out, hurriedly prepared scheme in the first place, there really wasn't for the election. It was sort of mid-year, like the last one. And for the next half of the year, really, there wasn't a minister giving any oversight to how the scheme was rolled out. You know, this last point, that Robodebt unlawfully and unethically, it did two things. In the main, it failed arithmetic. How did it fail arithmetic? It failed arithmetic by thinking that an average tells you something about the variable components. If somebody is on variable earnings or on and off or casual, that somehow an average speaks to its constituent parts. And you know, look, you'd you'd get a detention, I think, in you know, 3rd grade primary school, you know, for thinking that. But nevertheless, that's the arithmetic component of it. And it failed law. If it was the HSC, it failed legal studies, because it really is pretty easy law this to apply. In not understanding that under the Social Security Act, the onus is on Centrelink, is on the government to prove a debt. Robodebt instead sent people a letter that didn't tell them very much beyond that a hint that this was based on an average that could usually be found in the letter, and then said, you know, you disprove the fact that we think there's a debt. These debts, as I'm sure you know, went back as far as 2010, and they usually went back up to 7 years. They can go back indefinitely, as I'm sure you know, under Social Security law. There's really no limitation period that is meaningful, because the limitation period is a long one, and it only runs from the date that Centrelink knew or could have known that there was a possible debt. So people were being asked to disprove a debt from a very long time ago, when even for the first several months after Robodebt started to operate, even though the Centrelink website itself said keep your pay slips for 6 months and 6 months only. So that, of course, was deleted eventually. So I've made the point that's in that next dot point already. It was not only a failure of math and a failure of legal studies, but it was a failure of, I suppose, religious studies, ethics, and the unethical bit. I won't talk so much about, I've written quite a lot about these things if you want to chase them up. But it was unethical because so many of these alleged debtors were extremely vulnerable people who didn't have the capacity to, you know, contradict the powerful state. And it was unethical also in the fact that even though on 400 or 500 occasions the AAT was saying these debts are unlawful and we're setting them aside, never once, to my knowledge, did Centrelink ever accept its model litigant responsibility to accept that there might be a contrary argument and attempt to put a counter argument to defend its position. So, scale of the Robodebt issue, I'll run through this because keeping an eye on my watch, you know, the estimate of what was at the time of the thing fell down, there seemed to be still about 3.7 billion in some people's estimates. You can see those figures on how many Robodebts as at over that up to March last year, it's nearly a year ago. The value, that word valued is important because most of those 1.25 billion of debt had not been repaid voluntarily or garnished or in any other way recouped, but that was the potential size of the pool, if you like, of debt as at that point. There's some figures on, in a few cases, there was some exercise of the Social Security Act provisions to waive part of a debt, in part or full, but that's minuscule. If you're wondering what the average size of the debt was, I mean, averages are, you know, really, really important in the eyes of Centrelink. Average fortnightly income. So the average size of the debt was 2,184, but I certainly on the tribunal commonly encountered debts of, you know, $10,000 or more. As you know, most of those debts, even ones around the $7,000 to $8,000 mark, when calculated purely on the basis of an average, very early in the piece, the Ombudsman did some test calculations of what the true state of affairs was. I think there were 7 debts, and in just on half, the big figure dropped to 0, or at worst for the applicant, it dropped to a few $100s. And you know, for people thinking, well, geez, that's a really big variance between an average and the true calculation. The answer for that is earnings bank. The provisions of the legislation that allow the carrying forward of the portion of a person's earnings in a fortnight that fall below a certain figure, and the portion that falls below that figure does not count for the purpose of any reduction, does not count for the income test. Because the debts were over, you know, a year or more, or sometimes 7, it didn't take many of those correct applications of the true earnings coupled with the earnings banks to discover that the debt didn't really exist. I've made the point about how many of these clients were vulnerable, and for those of you who remember the economics editor, some of Victoria, I presume, the Sydney Morning Herald, or the Age down there, way back in April 2018 said, characterised Robodebt as a form of extortion, and said, you know, extortion is no way to fix the budget. In other words, to get yourself a surplus or fill a black hole. All right, so why was it unlawful? You know, this is the boring stuff, you know, other than for Social Security lawyers. It's because principally of the difference between the Social Security Act and ordinary civil debts and other parts of public administration, even at the Commonwealth level. And this section that says there's a debt if and only if the a provision of the Act constitutes it as a debt. That's if and only if. Those are the words. Another section of the Act makes it so. That was deliberately written into the Act in 1990. Why do I say deliberately? Because there was no such provision prior to the 1990 consolidation, the 1991 Act. And I chaired the group that for 2 years put together that now more, it was modern at the time, a Social Security Act, as it then was, later split off to become the Administration Act. Some provisions were taken out of it. So that was a deliberate decision. And so you've got to turn to a section that makes it a robo-debt type situation, a potential debt. And 1223 is the section that says, you know, if you were paid more money than you were entitled to receive, then the difference between the larger amount you were paid and what you should have been paid is a debt. Everybody, I guess, knows that there are rate calculators. That was something else that we put into the Act in that 1990s revision. And the benefit rate calculator is the one that is most commonly in play, because that's the one for New Start, but of course there's an equivalent calculator for youth allowance and some other quote-unquote working age payments. And all of those working age payments operate on a fortnight-by-fortnight basis, and then turn whatever the calculation is in terms of your entitlement in that fortnight into a daily rate. But the short point, that's why it's underlined, is that you must know what a person's earnings were in each and every fortnight of any debt period. Now we can go back to 1984, the McDonald case. This was a full court of the Federal Court of Australia, and that was the case. It said in circumstances like the raising of a debt, although strictly speaking, for evidence lawyers in the audience, it's not a traditional onus of proof, but nevertheless there is a practical onus that is borne by Centrelink. So that was a unanimous full court decision way back in 1984. Never been questioned since then. Go back even further. Brigginshaw. Brigginshaw was an adultery case, and for I can't see anybody, so I assume there are no octogenarians like myself who can remember that once upon a time one of the greatest moral stains was to be accused of being an adulterer. Well, that was the issue in Brigginshaw, and what was laid down by the High Court way back there in 1938 was that in certain circumstances the obligation to be for Centrelink to satisfy a practical onus of proof was raised, became a higher standard. And although adultery is no longer such an issue, being a debtor, and particularly if you're a lawyer, like many of you no doubt are in this audience, after all, only lawyers are, you know, capable of listening to boring people like me, you'd know, I'm sure all of you, that if you have a Centrelink debt, no matter how it arose, for the purpose of admission, you have to satisfactorily explain it away. Otherwise, your entitlement to practice is in jeopardy or won't be granted. And there's a very good article in the University of New South Wales Law Journal that set that out. Well, all of what I've got on that page was vindicated by Amato. those of you wondering about Brigginshaw, of course, will be thinking, well, what about that extreme activist left-wing judge, Sir Owen Dixon? What did he say about proofs in saying that in certain circumstances this heightened threshold arises? Well, this is what he said. Reasonable satisfaction is not a state of mind that's attained or established independently of the nature and consequence of the fact or facts to be proved. The seriousness of the allegation made, the inherent unlikelihood of the occurrence of the given situation, or the gravity of the consequences, being put on debt watch lists and having your credit rating affected, all go to determining what reasonable satisfaction of a tribunal means. And then these underlined, well, italicized words. In such matters, reasonable satisfaction should not be produced in inexact proofs, indefinite testimony, or indirect inferences. Now, of course, what at best was Robodebt seeking to do, other than turn suspicion into proof, or vagueness into something tangible, or to have people abandon logic. So that's why Robodebt was found to be illegal by the in the Amato case, and bear in mind that Centrelink couldn't even bring themselves to enter the court to attempt any defence. They folded before the case was due to be heard. Now, there are a few references there that some of you might want to have a look at later. That 2018 one in the University of New South Wales Law Journal Forum is really an elaboration of what is now the public decision, what is now the decision that's public, that I handed down in, I think it was March 2017, invalidating the Robodebt that I was then looking at on the basis of the application of all of those arguments that I've just been canvassing for you. In the article, I also alluded to, but it's now a matter of public record, that I went to some lengths to utilise my powers to require that Centrelink make a written submission in answer to all of those sort of points on that previous slide. They did provide a written submission brief, but it did not in any way, it wasn't relevant, it did not address any of those arguments. And I also, for good measure, invited Centrelink to appear in person. I couldn't compel that, and they declined to take advantage of that opportunity. All right, the capitulation. These are the 4 points that I suspect are familiar to this audience. Let's see. That's what was said on the morning of the 19th. Debts would no longer be raised solely, you can see that italicised, would require additional proofs. I've bolded that because it's palpably still illegal. Complete is the word that should appear there. That they'd been methodically reviewed. We didn't know how that was going to operate, and we still don't know I don't know anyway, what the form of the contact that's being made may be. The OCI is the official name that certain government senators insisted you had to call Robodebt, the Online Compliance Initiative. Nearly all of their correspondence was completely hopeless to start with, and only slightly less hopeless after Welfare Rights and ACOS and others had lobbied to try to get it improved. The review would establish whether further information is available. Again, this bolding, you see, because it has to be complete information, not further. and that things were being frozen until sort of, late February, early March, when we'll know how we stand. Now, there's the Australian's former cartoonist, Kadulka. And why is that quite a nice cartoon? Well, because I think what that 19 November statement was trying to say was that they were turning the mouth up the right way so that it looked like it was smiling, but it was still a Robodebt. And they're hoping that nobody will notice that that's all they've done. Fourth point, what is now required in respect of all of those 500,000 or more, because we don't know the figure, we won't know. In the Senate, although they'd been working away for 3 months, the whole team that was being questioned said, oh, when they were asked, can you give us a bit of an extrapolation, build an average kind of thing? Oh, no, we couldn't possibly do that. We've got no idea, So they've been keeping their cards totally close to their chest about the numbers. But it's going to be somewhere, around the 350,000 to up to around the 600 mark. And for all of those cases, just getting more proof points is unlawful. It still leaves the debt as an unlawful debt. Because, as you see with that first dot point, I've talked about that at great length. I'm sure you don't want anything more about that. So to your next question, is there anything wrong with Centrelink continuing to ask people for a pay slip or a bank statement? Well, my answer to that is, look, if it's readily to hand and you don't mind the trouble of uploading the thing because, you've got a working computer, and unlike down here at Culburra Beach, you've even got the NBN and it actually works. Well, yeah, of course, it's okay for you to ask and if you wish to upload it. But if the documents aren't provided when Centrelink asks for it, or the person does not reply to the request, and incidentally, it was the people who hadn't replied to Robodebt during its ordinary operation who were targeted first. I thought that was quite a sensible thing to do in the methodical reviews. But for any of those people, can Centrelink raise a lawful debt because you've said I don't have them, or I'm not going to provide them, or I just keep stum? I don't answer. And the answer is a flat no. No, maybe, no. And I think by now you'll understand from the reasoning why that's the case. So, compliant with the motto, what are Centrelink's options? It either must abandon the debt or those parts of the debt amount that it cannot prove with actual fortnightly income, or it must use its statutory powers to compel the production of pay slips from employers. Now, many of these employers are, in the leisure and hospitality industries, and they weren't doing the right thing. Went down here at now half of the people in that industry were significantly underpaying all of their employees. So I'm not just speaking as though this is a bit of a proposition on my part. There's evidence that not only that they weren't necessarily doing the right thing, but of course, the turnover of small business, particularly in hospitality and the sort of areas where young people on youth allowance and indeed the unemployed on New Start will often be working. So it's up to Centrelink to determine to use those powers or not. And pre-Robodebt, those powers were used in 7%, only 7% of all data matches where it looked as though there was a significant discrepancy between what an ATO average was suggesting and what the person had reported to Centrelink at the time. Why didn't they extend beyond the 7%? Their evidence to the Ombudsman in the first Ombudsman's report was, in answer to that, because it is not cost effective to do so. Fair enough, but that's a matter for administrative decision and efficiency. The law is clear cut. Will past debts be repaid? Well, they say they're looking at them all. I'm not sure how they're going to conduct this. Are they still applying some reverse, de facto reverse onus? Probably, but it cannot be done that way. Will debts be wiped or powers to garner information, as I said a few minutes ago, be used if there's no reply to contact? It must be, but will it? You know, I'm not the most trusting person in the light of the Robodebt catastrophe, indeed abomination. It's the worst piece of government administration from go to woe, and that, I mean, right to today in the government attempting to defend the indefensible that I've come across. So although you would have thought questions like that would have a clear-cut answer, that the rule of law as determined by the federal court, you know, is clear-cut, and so the answer to all of those things is, you know, that they should be doing the right thing. I'm not confident. Garnish sheet and repaid partly, must be, but will they? Same thing. Will interest be added to the refunds as required by Amato? Well, ditto, but if you've looked at today at the Guardian, I think, because as you know, there's a class action still on foot. The Guardian's got hold of some of the government's early defence, and it asserts that it owes no duty of care, and therefore there can be no damages paid, even though in Amato they had to concede that damages were owed, interest was owed to Ms. Amato for the money that was unlawfully retained for the period it was retained. So I wouldn't be holding your breath on thinking that the answer to any of those questions is going to be as favourable as the rule of law will require. The class action, of course, is saying there should be compensation considered for psychological trauma, you know, false accusations of debt and other harms. We don't expect that that's going to be, in fact, we know from today that they're defending that to the death. They don't want to see that. That's the link to the class action. There's a very large number of people in the pool now. What is it? 90,000? Or anyway, there's a lot of people. 5 main litigants, but there are a lot of people who have joined the class action. Of course, the class action, I've got a long way to go. I'm looking across at my watch. It tells me I've been intruding for, I was supposed to be taking questions about now, so let me just whip through this. This is the legislation that you know, looks to the future with the one-touch scheme, matching employer fortnightly reports of the monies they've paid to employees against what a social security client has said about, you know, the same fortnight. And it leads to almost contemporaneous matching, so it would mean that people would remember, the employer would still be in business, much easier for people to sort out because it's what the employer pays. And the legislation, if passed, is going to change the definition of income. At the moment, for all payments and for all time, income has been defined as that which is earned, derived, or received. And Harris and a whole stack of High Court and Federal Court cases that people might be familiar with, said those are separate words, and so it meant that people who were entitled to war reparations that weren't paid outside the country in question had that money deducted from their rate of social security because it met the definition of being derived, even though it had not been received and never would be received. So what Centrelink has had to do in order to get the tax office data, which is about money paid, and the converse of paid is received, is define one class of income, earned income, which already had a bit of a definition there, as now involving actual receipt and only actual receipt. Okay, so derivation or earning, being entitled but not having yet received the money because you've done the work or you've provided the contract but you haven't yet got your money from it, from your invoice or from the workplace. Those two are going to be removed from the definition. And this definition is going to apply right across the board. So it's a carve out from the old definition, and it applies to pensions. So to try to avoid there being too many conniptions for pensioners, they've got a provision that says for pensioner, if you've got earned income last month and it looks like you'll get the same amount of earned income next month, you won't have to report any fluctuations. You'll continue to get a standard rate of whatever your usual rate of income, earnings, reduced pension was going to be. Well, that's kind of fine for those people who do have stable part-time earnings, and maybe a slightly higher proportion of the pensioners in that position, but there'll be many pensioners who are in casual episodic work too. And I can see in the future, if this legislation goes through, that there's going to be a kind of a mini version of Robodebt for some pensioners. And of course, there will also be some difficulties for all of those people who are of working age and who have an employer who hasn't yet purchased and signed up with the one-touch software to report by fortnight. That's much more likely to be the small employers in the leisure and hospitality sectors, even though the ATO is making considerable efforts to try to, prioritise signing them up. So I can see some problems that will occur in the future. I won't hold you up on this last lot. What were the lessons? That everything failed, the auditor failed, the ombudsman didn't bother to ask the legal question, and when put on the spot by a senior barrister, the ombudsman's office people said, "Oh yeah, well we did ask, was Robodebt lawful?" They said yes, and when the question came, "Oh, and well, did you ask them what the reasoning was?" Because this came up after Peter Hanks gave his paper in the middle of 2017 at the Administrative Law Conference in Canberra, the national conference, saying that it was unlawful, as we've just been discussing. And they said, "Oh yeah, no, they said it was lawful." And so did you ask them the basis for, their reasoning? "Oh no." You didn't ask them for a written, opinion? "Oh no. Why not?" "Oh, well, we wanted to preserve a good relationship with the client department." Now, I've written a piece that's in the references that indicate that, frankly, everybody failed. I don't exempt welfare rights entirely from that, although welfare rights resourcing was much less than, other bodies in a better position. It's that one in the Alternative Law Journal that just come up in the print that you can't see unless you've got a magnifying glass. And so because I'm 2 minutes before I was supposed to be, I've taken 8 minutes of the 10 minutes of question. I'll hang about. There's no question, but problem about that. So I'll just put up the conclusion. There are all kinds of things that ought to be looked at in the future. And I'm now available to take questions.
Excellent. Thank you. Thanks, Terry. It's Carly here again. So I've got a couple of questions that have come through. Firstly, though, thank you for a very comprehensive presentation and lots of further reading for people to check out as well. So firstly, I've got Kylie's question. So she's mentioned that a couple of their clients have said they've spoken with Centrelink and that they've been told that the debt is not a robo-debt. So what would the difference in the debts look like, robo-debt versus another kind of debt through Centrelink?
Yeah, that's been on the TV a few times. You really need to look at the at papers that the person may or may not have. So if somebody is just told, and a lot of people were told this on the phone during Robodebt, they may still be just being told this on the phone without any elaboration. What they need to see is the calculation sheet that is showing fortnight by fortnight what was the income that the earnings that the person reported, and what is it that Centrelink is saying the tax office or the other information contradicts that with. And with robo-debts, the column that they're relying on, the higher figures of earnings that they're relying on, usually repeat for 5 or 6 or 7 fortnights in a row. Why? Because they're an average that's been extracted from tax office data. So that's the best indication, but to be in a position to be able to do it that way, you need to ask for the debt calculation to be provided by requesting a review officer review of the alleged debt, because part and parcel of that will be the inclusion of those papers, and also a short, not always very fulsome or adequate, but some attempt to explain in a paragraph or two what the review officer is saying is the reason that there is a debt. One or other of those two should give a pretty fair indication as to whether it is a robo-debt or not. Generally, robo-debts, I've had people email me after they've seen my media appearances, etc. And numbers of those are pensioners, and nearly always they're not a robo-debt. They may have another problem, but they're not a robo-debt because they weren't on fluctuating incomes, and it hasn't been calculated on the basis of a tax office match of earnings data. Now, Centrelink was, and I don't know whether they still are, playing ducks and drakes, being naughty, in not accepting people's request for a review officer, authorised review officer review. It's a statutory right that people have, and quite often Centrelink in the past was saying, oh well, we can't do that because we haven't yet determined whether there's really a debt or not. We're going to we can't do anything until you provide all this information that you tell me that you can't provide. You've just got to be forceful. That's where welfare rights, that's where asking the officer to put that in writing and to insist that it be put in writing, to ask for the person's identification. They won't necessarily, they usually won't give you their name, but to give the their personal identifier. They're the sort of, you have to be pushy, is the long and the short of it. But yes, it's true that while most of the people who think they've got a robo-debt probably do, quite a reasonable small proportion of them actually don't, and it's a different kind of issue.
Okay, cheers. Thanks, Terry.
Does that help?
Yeah. So there's 3 more questions that have come through, and we may have a couple more. Siobhan has asked or mentioned, if people don't reply to demands for pay slips, how long does Centrelink have to decide before it starts pursuing employers or financial institutions or makes a decision to wipe the debt? Is there a time frame, or could this debt be held over people's heads indefinitely?
Look, there hasn't in the past been a time frame. Those sorts of things were being canvassed at the Senate hearing in December, just before Christmas, and there was no indication that they did not announce any new procedures like time limits or anything of that kind. The current Centrelink administration, and indeed its predecessors, the old Social Security and so on, for all of last century, or most of last century, was pretty notorious for inertia. Can they hold the sort of the potential emotional threat of the debt over you forever and a day? Yes, they can, and they probably will, because they're they don't have as many staff, they don't have as many competent staff as they once did, etc. And all of these things, make it more likely that inertia inaction is going to be the response to people's concerns. And that's why insisting on having an authorised review officer review of the alleged debt is what you should insist on. Just insisting on it in a number of cases that I'm familiar with, where people have consulted me informally, leads the inertia to move into action, and in a good percentage of those cases to the conceding that, well, actually, no, we can't raise a debt at all, or we can't raise anything like the size of debt that we thought we could. So that's what I meant by being pushy. And now, and keep your eye open for early March, whenever these 350 people who've been slaving away for 2 months over Christmas, etc., finish their work. We might start to get something a bit more definitive about some new procedures that might then be announced. But at law, no, it's no debt, and so you can assure people not to be worried about it, provided you're sure that it's a Robodebt case and they don't have the fortnight by fortnight information. You can be absolutely firm, clear-cut, 100% guarantee that there is no legal debt, and therefore that the person shouldn't be worried about it. But to get rid of it, off their slate, they should be pressing their review rights.
Okay, so following on from that, Stuart has asked, so I think you might have answered this part of the question around how effective is asking for an authorised Centrelink review office of the Centrelink debts. But the next part of his question is, and what is the consumer's next step if this fails to give them any reasonable explanation of a debt? Can you ask for a second review officer to review the debt?
You can, actually. For the really technical lawyers, there's no, functus officio. That we always like Latin when we have to talk about. There's nothing that actually says that once something has been looked at, it can't be looked at again. And that's actually important to remember right across Social Security, not just Robodebt. So that's the answer to that one. You could ask for a second. In the past, the answer to the first part of the question, how effective was asking for an authorised review officer? It was effective in actually, stopping the inertia and getting the next step along the pathway taken, but the review officer did not ever change, did not ever accept the illegality of the debt at that stage. Now it may be that they are going to, when they review a proportion of these debts, who knows, they may be confirming their illegality and saying there's no debt. But in the past, getting the authorised review officer was the critically important mandatory step that had to be completed before it was possible to go to the Administrative Appeals Tribunal, the first tier tribunal that has its hearings in private. Now, in the past, in the time when I was on it, etc., before the federal court case, you know, there were 400 or 500 of them that were being struck out as not being a debt on the basis of the reasoning, you know, I've been talking about. We do now know that the instant an authorised review officer's Robodebt lands with the first tier AAT, there is a standard letter that goes out and says it's not a debt. Indeed, I was questioned by a journalist because the letter actually calls it Robodebt. Call a spade. I said that was exactly what it should be called. You know, I mean, it's because what the ordinary person understands these debts are about. But yes, they don't now even list them. They simply settle them pre-hearing is what I've been informed. Many people in this audience would be in a better position. There may be some that are not panning out that way, but certainly that's the case here in New South Wales, as I'm informed.
Thank you. So another question from Kayleen. What if the client has already been taken to court, charged, and now on a corrections order?
Debts and prosecution for the offences, the criminal offences under the Social Security Act for misrepresentation and all the other things, which is now fairly rare. The two bear no relationship, the one with the other. The fact that you have been convicted of an offence of, you know, willfully obtaining monies to which you were not entitled. That's roughly the way that section in the, again, in the thousands, late in the Act is phrased. Never was any barrier at all to a person then saying, I now want my debt reviewed by an authorised review officer and or the Administrative Appeals Tribunal if the review officer doesn't adjust it to my satisfaction. And in hearing those cases in the AAT, they're decided in exactly the same way as would be a case where there was no conviction. The two things, you know, they're absolutely no relationship the one to the other than the common facts. There is no way in which quote unquote findings in the criminal case are binding upon or even necessarily going to be considered by the Administrative Appeals Tribunal. Usually they're not, because there was no representation, and if there was representation, the poor lawyer had not clue, no more clue than the man in the street or woman in the street about how Social Security works. So, you know, they were a waste of space. Might be good criminal lawyers, but you know, they knew nothing about Social Security, yeah, most of them. So yes, and there are policies that used to, that the tribunal still, to my knowledge, subscribe to, that if there is a criminal case pending, then any administrative review, if it's launched in time, will be expedited. So that not only is the debt sorted out properly, but so that, if appropriate, that can be fed into the criminal prosecution. There used to be a group of lawyers who thought, you know, no, this would prejudice your case and we better have the criminal law matter first and then and only then go to admin. Well, you know, better in the order I mentioned, but it doesn't matter. The two are entirely independent.
Just to follow on from Kayleen there around her client being Indigenous, illiterate, and not knowing at all how to even fight this matter, and seems unfortunate that that person came to the attention of a lawyer or a community centre when it was a bit too late and the court date had already been set. So that's very unfortunate and probably not uncommon. Thanks, Kayleen.
Yeah, it is common.
Yes. Terry, there's many more questions. I hope that you're happy to stick around for another 10 minutes or so, and thanks to those.
As long as people wish, yeah.
Great. So Len has asked, Why are bank statements okay as they won't provide evidence of fortnightly gross income earned? No.
Yeah, well, exactly. Because a very rough and ready back calculation was able to be made from the take-home pay to determine what the gross pay is. Yes, everybody listening would know, which always upsets members of the public who know about tax and think that it's, only a taxable income that matters. But in Social Security, of course, apart from being earned, derived and received until, this change goes through perhaps, it was always and still is going to be gross, the gross amount, rather than the take-home pay. But from the very beginning in the early 2017s, even in my decision, I can see it in that one that's now been made public in the Senate and on the Guardian's website, was that you could make a cautious, prudent sort of back calculation as to what the gross income was. Put in a bit of a margin of error and count that and only what that calculation then yielded as a debt. And yes, if it shortchanged Centrelink, by a few dollars, they were happy enough with that because it, determined the matter, and it was fair to clients too, provided that is that the wage had always gone into the bank account, and these days generally that is the case. So the problem, incidentally, for those of you wondering, well, why didn't people do what Centrelink said when they say you give us your pay slips? Well, I didn't keep them, but what about bank statements? Surely you can get those from your bank. And of course, most banks, for the older statements, if you haven't kept them, charge, not quite like a wounded bull, but they charge more than a client can afford. So that's why the department, using its compulsory power to demand free of charge to the Commonwealth that bank statements be provided, is a proper way to proceed if the pay slips can't be found.
Thank you. Amanda's question is, what options do current Centrelink recipients have if their payments are being garnished? Apparently this is not stopped despite the review that they are having, so the review that Centrelink are doing.
They should be insisting on it, because even in the Senate, as I recollect, that was indicated that the policy would be that that the freeze would go in. I think that's actually point 3 or point 4 even of the, that 19 November statement. I've certainly heard that it hasn't been happening as it's supposed to happen. If people are wondering what's going on, that's a thunderstorm that can be heard in the distance. One should be pressing for that to be done. The garnishee, of course, is imposed by the tax office. The tax office, until soon after the settlement of the case, was saying and defending its position as being a mere instrumental agency, and strictly that's probably correct, that that they garnished on the basis of whatever it was that Centrelink was saying was a lawful debt. You saw that exchange in the press recently between the senior legal officer of the ATO and Centrelink, etc., of the department, etc. So it may be that the kind of case you're referring to is one where the information had been passed across to the tax office before the November settlement, and that for whatever reason Centrelink hasn't withdrawn or confirmed that this too is a robo-debt and therefore shouldn't be collected. So that's what one should press for. But look, don't. I mean, and of course the person wants to get the garnishing stopped and all the rest. But at the end of the day, Centrelink, the government is going to have to repay any and every Robodebt that is insisted upon, no matter whether it's been garnished fully or paid, quote unquote, voluntarily, no matter what the route. That slide that I had up early, the answer is that it has to be repaid in all of those circumstances with interest. With interest on the money withheld.
It's really good. We're almost there, so just a couple more questions to go. Terry, thank you for sticking around. Len's just asked also, given the order of the Federal Court and the acceptance of this being an unlawful issue, what basis, if any, does Centrelink have to hold money previously recovered while conducting its review? So once it's been identified as unlawful, shouldn't they refund this money while they seek their exact proofs? And isn't this an issue for the Ombudsman if they don't?
Well, technically, yes, but look, as a matter of administration, I'd have to say that it makes sense to, keep it for the additional how many number of weeks, provided it doesn't go on for months, that it takes to complete the review of everybody's case and be in a position to know whether all of the debt was based on the average or whether there were some small portions where, there is a real debt because there's a discrepancy between the reporting time for Centrelink purposes and the period that the money was actually earned or received. They often didn't match, and that can account for there being small numbers of dollars, a couple of $100 of a larger amount being a true debt for that reason, and to shunt the money backwards and forwards. We fund it all and then discover that, well, no, actually, no, we want 5% or 7% of it back because it really is a debt. That wouldn't make much sense to me, and you'd be hard pressed to get a court to write an order in terms and knowledge like that, saying no, it just has to be done instantly. They'd be more likely to adjust the terms of any order to sort of reasonable administration, I think.
Fair enough. Okay, thank you. Final comment also from Len, just saying that they're pretty sure that prosecutions are all based on fortnightly earnings information, i.e. employer reports, and not ATO averaging. At least that seems to be the case in Victoria.
Yes, that would be my experience too. I mean, I sat on these cases for nearly 40 years, and these kinds of ones came up, reasonably regularly of there being a criminal prosecution. They dropped off recently, but I'm very pleased to know, and indeed that's a policy now of the prosecution and fraud detection, that they want to prevent fraud rather than prosecute people after the event. So yes, I didn't ever see one where it would be a Robodebt, but Robodebt's not the only sort of issue. The fortnightly amount is not the only matter. The waiver powers and the write-off powers would quite, well, say commonly, not uncommonly, lead to a reduction or even on occasions the non-recovery of a debt, even though it did arise from earnings. So what I'm saying is it's a broader issue in the AAT about the raising of the debt and its waiver or write-off. So yeah.
Okay, I think you've effectively dealt with all of the questions that came through. Thank you so much, Terry. That was really good and a very detailed examination of the Robodebt issue. Hopefully we'll have some further potentially Robodebt related seminars later in the year. So do keep an eye out for those for people who are interested in this area of law. But for now, I'll close off the webinar for today. Thanks again to Terry, and thank you for everyone and your attention and your great questions that you've sent through. Cheers and have a great afternoon.
Thank you. Bye.